Yeah, let's get going, Zoe, I think.
Okie doke. Well, we might as well kick off. It's the time. Well, hello, everybody, and welcome. And I'm so glad to see you all in such large numbers because apparently we have 160 people registered. And it just confirms how much interest in rights of nature there is, which makes my heart sing. My name is Zoe, and I and my small organization EarthThrive are co-organizers of this Rights of Nature and Mining Resistant webinar series, together with our friends from London Mining Network, Gaia Foundation, under the roof of Yes to Life and No to Mining network, where we are all members. And basically, this is what it is: Yes to Life, No to Mining. So as there is such an interest in tonight's webinar, I will just keep our intro very short so we have as much time as possible for questions and discussions after the presentations. So I will just say that these webinars are a continuation of a project we started within London Mining Network about 2 years ago on inclusion of rights of nature into our mission statement. And I'm very, very pleased to say that the proposal was successfully adopted early in the year. And the wording of rights of nature can now be found in our mission statement on our website. Now that this first crucial step was made, the idea is to put the rights of nature ethics into practice and actually use it on the ground to fight off mining and other extractive ecocides. So how do we do that? Well, we are hoping to have a toolkit developed sometime next year, hopefully, so that the communities can use it in their work. But in the meantime, I had a chat with Hal from Gaia Foundation, who are also doing some fantastic work on the subject. And he suggested doing a series of webinars where we could showcase actual initiatives on the ground. And to that end, we will be presenting you a first-hand community testimony from Carlos Zorrilla from INTAG in Ecuador, where communities have experience using rights of nature approaches to stop mining exploration. So it's a first-hand experience on the ground, which is what I'm sure a lot of people are very interested in. But first, we're going to start with our own London Mining Network's very own Sue Willman, who will be talking about what rights of nature are. She will be giving us a brief history of the movement. And within her really excellent presentation, she will also be tackling some rather provocative questions that people usually have when we talk about rights of nature and inclusion of rights of nature into our legal systems. And I personally am also very interested to hear that because I'm an environmentalist, not a lawyer. So she will have some very interesting points to discuss afterwards. Now, Sue, our first speaker today, got involved in the UK wildlife movement back in 2011, so she's rather experienced. After hearing Nimo Bassi activist, he's a really, really fantastic activist from Nigeria, talk about pollution of the Niger Delta, saying, keep the coal in hole, keep the oil in the soil. Do you really need a car? She's also an assistant director and supervising solicitor at King's College Legal Clinic, where she combines her interests running a human rights and environmental legal clinic. She has recently worked with students to file a legal intervention for local indigenous people affected by mining in Northern Colombia for AB Colombia and Colombia Caravana and London Mining Network, of which she's a trustee as well. She's also a solicitor at public interest legal aid firm Dayton Pierce Glynn, where she works on cases involving migrants, environment, and human rights. And she's a member of the Climate Law and Governance Center at King's. Wow, that's quite a biography, Sue. So without further ado, Sue, the floor is yours.
Hi, everyone. Can you see? Hopefully you can shortly see my slides. I'm shocked and excited tonight because I thought I was going to be having a chat with about 20 or 30 people about how we could introduce wild law into mining, and I find myself with more than 100 people registered, and this is the second time in 2 nights when I've had more than 200 people registered for this kind of event. Clearly this is the time, perhaps it's one of the advantages, one of the very few advantages of COVID, that people have started getting really interested in climate and environment and rights of nature. And I'm very pleased that LMN and Gaia, and Zoe's organisation have seized the moment to start talking about it and sharing ideas and seeing what we can do with it. I had got a little poll which I wanted to use to find out how many of you already know about wild law and rights of nature. So hopefully you can see that poll. I just wanted to get an idea about people's knowledge so that I can pitch the talk accordingly. So Zoe said, as Zoe said, we have got a few more controversial subjects, and wild law isn't an easy way into environmental law or to protecting mines. I think we need to understand that. I think we choose it because it fits with our philosophy, not necessarily because it's going to make everything very much easier. So I wanted you to think about, how do you balance the rights of nature and the rights of humans where they conflict? Last night we talked about how humans are part of nature as well as being separate from it. But I just wanted to mention a recent Colombian case. In Colombia, they have these wonderful paramos, which are like moors. I don't know if you have them in Ecuador as well, Carlos. They're like, they're kind of a warm, yeah, okay. So if you imagine something like the Scottish Highlands or Dartmoor, but it's on the top of a mountain, and it has a kind of almost like a semi-tropical terrain with cactusy type of plants, and it often generates a huge amount of water. There may be an opportunity to mine underneath though, so the local residents may be trying to protect it from a rights of nature point of view, but that may come into conflict as it did in Boyacá in Colombia in relation to the Pisbar paramo with workers from a local mining company, a coal mining company. And they tried to argue that they should be consulted before the paramo was basically turned into a kind of natural park or given more protection. But luckily for the rights of nature, the administrative tribunal took into account an earlier Colombian legal case relating to the rights of the river. And they decided that although, of course, the miners should be consulted, the environmental rights needed to come first, and they should have the highest degree of protection. So that's just something to bear in mind as we're having our discussion tonight. And then I wanted you to think about who is actually going to have the rights of nature. The river that you can see at the top is a river in northern Colombia, which is what the case I was involved was about. You have Ben Nevis, the highest mountain in Scotland, on the right, which people have tried to argue for rights of nature. We have COVID. Whether or not the virus is a living thing is kind of scientific debate, which is probably above me, but there are arguments about whether or not viruses are part of nature. So I thought it's also interesting about how far we go with the rights of nature. Do we start with a river and a tree and then try to persuade people to go further, or do we start by arguing for the whole of the natural world and the whole of ecosystems? So what's wild law? I like the idea that I can call myself a wild lawyer, even though it's not quite as sexy as it sounds. So currently our legal system is very much focused on property, and that's the argument used against it. But there's nothing new about individuals not having access to legal rights, not having access to the court, not being allowed to own property or inherit property. In the US, slaves were excluded from such rights, and Native Americans. In Europe, women and married women couldn't own property until not that long ago. And by the same measure, there are people who can't appear in court, like children and mental patients, who can be represented in court and can have legal rights. So if a child can be represented in court, why can't a river or a tree also be represented in court? And I also wanted to think about some current legal principles that are used in environmental law, which sort of touch on the edges of wild law. The first is the precautionary principle. The idea is that nature's fragile and we don't have enough scientific knowledge to know if we can reproduce it. In the UK, 15% of our species are threatened at the moment. And if they go, will we ever be able to get them back? So the precautionary principle is the idea of erring on the side of caution and taking the best possible measures to protect nature. There has been this idea of having environmental impact assessments before you have any development. Well, you know, that's generally created a lot of work for people that carry out environmental impact assessments, but hasn't necessarily protected the environment. And sustainable development and the ideas about marketizing the kind of green economy also haven't gone as far as we would like. So that brings us to the idea of wild law and the rights of nature. And it's not a new idea, aside from indigenous rights in Western culture. Back in the late 1960s, the Disney Corporation decided that they wanted to build a skiing resort in the Sierra Nevada mountains in California. And the Sierra Club, which was a club of walkers, argued that they shouldn't, that it would damage the mountains and the trees and the wildlife. And it went all the way to the American Supreme Court. And I'm sad to say that in the court case, they didn't succeed because it was found that they didn't have standing. The Sierra Club didn't have a property right in the mountains, and so the court found that they couldn't bring the case. But what's interesting about it is it's the first case probably where this rights of nature idea was discussed, and a dissenting judge talked about if a ship has a legal personality, then why can't valleys, alpine meadows, rivers, lakes, estuaries, beaches, ridges, groves of trees, swampland, or even air? And it talked about how the river is the living symbol of all the life that's within it and around it. And it's rivers that we're going to talk about mostly in my talk this evening, because I think they're probably an area that we can lobby around, and they're very closely connected to mining. We usually find water where we find a mine. Much more recently, Cormac Cullinan, who's a South African lawyer, wrote about wild law and wrote a kind of manifesto for what he calls earth justice, based on some spiritual writings. And at that time, it all seemed rather a unlikely idea that was never going to happen. Even by 2011, when I came across Nemo Bassi, the other people that were involved in the wild law movement were, apart from indigenous people, of course, were the Occupy movement, anti-capitalist protesters. So then fast forward to the last decade or so, the UN hasn't quite gone as far as to talk about rights of nature, but it has proclaimed that the 22nd of April every year is International Mother Earth Day, and has spoken about Earth and its ecosystems being our common home, and linked them to economic and social development. So then we have to turn to Latin America, because the heart of the rights of nature movement comes from indigenous people. They have a view of the world and maybe Carlos will tell us some more about it, or and seeing nature as Pachamama, Mother Earth, as a kind of living being. So the idea of separateness that Western cultures have, most Western cultures have, it just doesn't exist within this indigenous way of thinking about the world and thinking about nature. So tonight we're not just talking about changing a legal system or environmental law. We're talking about changing whole way in which most of society thinks about things and thinks about the world around them. We're talking about whether people are willing to move to a different way of living and learning more about a different philosophy. In African culture, the idea is more about custodianship. So there's an idea of sacred sites, and the African Commission has acknowledged the official role, and they're linked to the rights of nature. And in Asia, there's also an indigenous tradition, and we'll hear later about how that's worked in India and Bangladesh in terms of protecting the rights of rivers. So we go back to just 10 years ago, where the World People's Conference on Climate Change adopted a universal declaration of the rights of Mother Earth. It's no surprise that countries like the UK and most European countries haven't signed up to the declaration. Some Latin American countries have signed, and South Africa, I think, has signed. So I mean, Zoe may know better than me the number of current signatories, but I suppose the point of the declaration is really to start people thinking about the idea and to be used as a political tool, because what we're talking about tonight is as much about campaigning and about political activism as it is about hard legal rights, given that wildlife is very much in its infancy at the moment. And here we have Article 2 of the Rights of Mother Earth, which describes the inherent rights when you're talking about rights of nature. And I wanted to then apply some of those rights to a river and to some of the other entities that we looked at the beginning, like the mountain and like the virus. But first of all, there's one plant that I'm aware of that has a legal right. This is wild rice, and it's been given this right by one of the First Nations in the US. And I think, in contrast to what I talked about at the beginning about the conflict between humans and nature, this shows where protection of nature is very much protecting the community and protecting nature at the same time. So it's illegal for any business or government to violate the rights of the Manumin. You can't have a permit, authorization, or activity to allow its rights to be violated, and it's punishable under tribal law. People can be fined for any damage to the activity, and it's the nation who are custodians of the Manumin, which is something important in the discussion about rights of nature. If you decide that a river has got rights of nature, who's then going to enforce it? Is it going to be the government, which is probably the body which was responsible for polluting it in the first place? Or should it be local people and communities who can come together to protect the natural entity? So before I go into some of the laws relating to rights of nature around the world, I wanted to talk about the case that I was involved in a small way in Northern Colombia. People who are working on mining around the world, including London Mining Network, have been working for many years in Cerrejón, which where there's the world's 10th largest open cast mine, and where there are also perhaps 20 indigenous communities who've been displaced by the mine, and whose lives have been damaged in many ways by the mine. And here's the river that runs through their territory. It's called the River Rio Hacha, and it has tributaries. And the one that we're interested in tonight, I don't know if you can see it, depending how big it's probably quite a small tributary. I don't think it's showing. It's called the Arroyo Bruno, the Bruno River. But as we think about whether or not a river can have rights of nature under the treaty, these are the points that we looked at just now. And Colombia was one of the very first places to find that a river had rights. This occurred in relation to the River Atrato in 2017, it's known as the Judgment of the Atrato River, and a local NGO, Tierra Digna, brought a claim for Afro-descendant communities. They were interested in the right to a healthy environment because of large-scale mining activities. And in the judgment, the court not only upheld their right to a healthy environment, they also acknowledged the rights of nature of that particular river. And they specifically said that it was an autonomous entity with the rights to protection, conservation, maintenance, and restoration. And they also used that guardianship idea. So they decided that there should be an advisory team with members from Scientific Institute and World Wildlife Foundation in order to protect the river. So that brings us to Cerrejón itself. This is how the open cast mine looks, and there are indigenous communities living just 2 kilometers away, the provincial community from this. And as a result of the mining, wild animals are threatened, and here's a list of them, which I like to read if you don't mind, because I think it's quite compelling. And this is simply the wildlife. This isn't the trees, this isn't the insects or the bird, or well, there's 1 or 2 birds. So it's the jaguar, the night monkey, the tiny yellow bat, the ocelot, the capuchin, the slider turtle, the cougar, the otter, the northern naked-tailed armadillo, the macaw, the tiger cat, the margay. Meanwhile, Cerrejón has been importing millions of tons of coal. It exports into Holland, it exports into Ireland, and obviously generates a significant profit. And this is a very dry region. It's one of the driest zones in Latin America. There's periods of drought. It's affected by climate change, limited rainfall over a few days of the year. And here is Simeon, who's a member of the indigenous community that lives just that 1.5 miles or so from the mine. And here's a bottle of rainwater, which is that color for obvious reasons. And he could remember a time when he and his family could use bows and arrows to actually capture fish in the river, and also time when they had a lot of traditional knowledge from medicinal plants. They could heal themselves, and lots of those trees and plants have died, and they have their animals. They have a few livestock within the small community, and those are sometimes born with disabilities or stillborn. And here.
So sorry, you've got about 5 minutes or so.
Oh, okay.
So sorry to cut you short.
That's right. Thank you.
Thank you.
Anyway, the coal mine decided to divert the river. First of all, they decided to divert the main river. The community fought against it, and then they decided to divert a tributary. And this is the river where people wash, where they get their water. And so they wanted to argue that the river should be preserved for them. And other communities around the world have done that. There's a list of some of them here. So the case was brought against the coal mining company and against the government who were giving them licenses, and against the environment minister. But at that stage, the YU who were bringing the case didn't argue about the rights of nature. They made other arguments, but the court found that a kind of panel should be set up to investigate what should happen, and that a local court should have some kind of supervision over it. Unfortunately, the company just decided to divert the river anyway. And at the point that we got involved and made this argument that you can see reference to on the right, by filing an amicus on behalf of the NGOs AB Colombia and Colombia Caravana with the help of London Mining Network, the river was dried up. This is before, but obviously if you move the water from a river, you can't just move it back afterwards. You basically are killing the river. Anyway, we tried to link the rights of nature, because it hadn't been argued before, to the precautionary principle, which had been argued about before. And well, that case is ongoing, but sadly that river is no more. No doubt Cerrejón might want to move further rivers. However, we're going to hear a better, happier story, I hope, from Carlos, where there is a right to nature in the Constitution. In Australia, they have granted river protection through a statute to the Yarra River. And in India, in a local province called Uttarakhand, the rivers Ganga and Yamuna were given a status as living human entities. There was then an argument about who was going to look after them, and the Supreme Court overruled the decision. However, again, I think that case is going on, but however, a river has been granted rights in Bangladesh, and the movement for rivers to have rights is very powerful in India. And then in New Zealand, quite a very strong act based on traditional Maori practices. The Wanganui River was given status as a person. So to cheer us up, here are all the, or most of the ecosystems around the world that I'm aware of that have managed to get legal rights, whether by bringing legal cases or by political campaigns, so that it's become law, as in the New Zealand example, the Bangladesh, the New Zealand example and the Australia example. In Colombia, also, the Amazon's been recognized as an entity, and Uganda has got a rights of nature law. So I know I'm nearly out of time. I wanted to compare those to other legal strategies. Those of us who are working for nature and communities around mines know how tough it has been. And we were given a boost recently in the Urgenda case in Holland, which was brought in the name of children, about the rights of future generations. There's a movement for due diligence laws, and there are tort cases for damages which take years and years and cost millions of pounds, and which most people don't ever have any chance of bringing. There are soft law complaints that can be brought, but there's no way of enforcing those. So the other legal strategies are all fairly challenging as well. So I think I'm nearly at the end, and that leaves us with these questions that I don't know, Carlos can answer, or maybe you'll go away and think about them, and we'll debate them at future similar events. So how do we deal with the conflict between the rights of mining communities and the rights of nature. At times they'll coincide, but at other times there may be some conflict. And also, how do we deal with the idea that giving rights to nature obviously means that harm will be caused as well, because nature's not some romantic, sentimental thing. Obviously, it works, you know, through harm and through survival is also about killing. But overall, I think that wild law gives us a great opportunity, and if anyone's interested, I think Zoe's going to share some resources for people of you who, according to your poll at the beginning, know a little about rights of nature. I hope this has interested you to know a little bit more. Thank you.
Sorry, I was muted. Thank you very much, Sue, for the really excellent presentation and for saving me having to write it all up. You did a fantastic job, especially you being a lawyer. You presented it from the point that is very practical for a lot of people, and you've tackled some very important questions. And I especially love that you've included mosquito at the end, especially relevant for me because I'm working on rights of nature and pesticides. And we will be talking about rights of nature and insects and, you know, in relation to pesticides. And the first question everybody asks are mosquitoes. It's like, well, what about mosquitoes? It's like, so, you know, that was very insightful of you. We will discuss that, and I'm sure our viewers have a lot of questions on the subject. But right now, I'd like to present our second speaker, Carlos Zorrilla from Ecuador. Now, he's a long-standing activist, some 26 years, as I understand. And Carlos's community has successfully resisted copper and gold mining in Ecuador's very biodiverse northwestern intercloud forest region. And we all know that cloud forests are disappearing at a horrendous rate. And they've been doing that for over 26 years, using a variety of tactics. So it is really good to know that he and his colleagues recently won a historic rights of nature victory. And they successfully argued that advanced mining exploration would push two endemic frog species and many other endangered species to extinction. And as far as we know to date, that's the first and only successful rights of nature against mining in Ecuador success, and the using rights of nature as a tool to push off mining ecocide. And it's very interesting that it's done on the basis of two small frogs, hardly an inch or 2.5 centimeters big. You know, usually it's the emblematic species like, I don't know, elephants or lions that are, you know, argued when we talk about saving an ecosystem or nature. But look at them, gorgeous, tiny little things. And, you know, many people would just disregard them as, oh, who cares, you know, little frogs. But they have equal right to life like everybody else, you know, and to see a case like this being won on the basis of rights to life of these little creatures, it's just amazing. It sets a fantastic precedent, even for us who do not have rights of nature enshrined in our own constitution and laws. But I'm sure we can take something from this. And that's why I find this particular case very, very fascinating and very relevant. So I don't want to take any more time. Carlos, over to you, please.
Thank you. And it's really impressive there's so many people interested. I have been in these conversations before, and you're right, maybe 20, 30 people even want to sign up, and 10 or 15 actually join. So it's heartening to know that there is more and more interest in the push for rights of nature. Let's see, where do we begin? You mentioned that the rights of nature is incorporated into Ecuador's constitution. Ecuador is the first country in the world to incorporate the rights of nature into the constitution, and this is in 2008. And it's kind of a long story as to how that came about, but it is, as you also mentioned, a reflection of a vision of life from the indigenous people of Ecuador. There's 12 tribes in Ecuador, and they all share this vision that Earth is alive, and that it's obvious. Why shouldn't they have rights? And the question for all of us should be also, why should only humans have rights when everything has been around here much, much longer than we have? And we took that idea and we decided to use it in this constitutional protective action. It's like a precautionary principle. We argued that just the exploration, which is very important to remember. I'm not even talking about exploitation, which is very unique for this case too. Where we successfully argue, that just advanced exploration in this very, very diverse area of Ecuador would definitely push these two species to extinction. And they are only found in the mining area, nowhere else in the world, within this 5,000 hectare piece of land. Ecuador is unbelievably biodiverse. There could be orchid or frog species right here where I live, and you wouldn't find one 5 kilometers away. So we use this argument, but we also said that there are several other critically endangered species of animals, including monkey species in this area that's critically endangered, the brown-faced spider monkey. There's another frog species that, besides these two, there's another frog species that's critically endangered. There's a fish species. There's bears endangered. The list is really, really long and depressive. So we said just the exploration will contribute to these species going extinct. It was incredible that the lower court judge would decide in our favor. Why I say that? Because the lower courts are much more likely to be influenced or pressured by the government, just outright. They'll call up and say, do you realize that if you stop mining, the government will not have any money? So and now we're right on the pandemic where the economic crisis has just completely destroyed the most sources of income for the government. So there's a tremendous amount of pressure to let all economic activities, to remove all shackles to economic activities. So I thought that the judge at the lower court would maybe even succumb, give up, and say, no, I can't go against the government. We need money for the hospitals, which is the government's argument. We need money for roads. We need more education. Where are we going to get the money now that the economy is in shambles? So you're fighting all this, especially right now. The judge was really, really very, very courageous. A woman judge sided with us and said, yeah, indeed, species have the same rights. And these two species may not benefit humanity, which is an important point also, but they have a right to exist. We were thrilled by this judgment. Obviously, the government appealed. And this is the other chapter in the story. I was just looking at all these documents. I just got all these documents from the court. And these are new actors that want to be taken into account for the appeal. Originally, we took the Minister of the Environment and the Attorney General to court, saying that the rights of nature would be violated and they are directly responsible, these two actors. We didn't want to complicate the scenario, that's why we kept it to two actors. The judge opened up the lawsuit. Instead of just being protective measures to protect these species from going extinct, the judge looked at all the documents and said there were other rights violated and that they must be these elements that are violated in nature, like the rivers, that they must be rehabilitated, remediated. And so she added protective actions besides what we originally presented, which was a precautionary measure. So that will open it up. And now for the appeal, which is still not happening, the state mining company, Codelco, the world's largest copper producer, the Ministry of Energy and Non-Renewable Resources, and also I forget what other entity is involved. Yeah, besides the Ministry of the Environment and the Secretary of Water. Now, all of a sudden, we're dealing with 24 lawyers, where before we were dealing with 3 or 4 lawyers in the appeal. And I've been looking at some of their arguments, and a lot of it is companies have a right, and if the judge is violating the right for companies to operate in Ecuador, or the right of judicial security for those companies to be secure working in Ecuador over and over again. And this is the case, a similar argument is being used in another case that's in the constitutional supreme equivalent of the Supreme Court in Ecuador about the rights of nature. It's an area close to where we live and where we presented the lawsuit, which is Junín in the Intag area of Ecuador. There's another fight for the rights of nature that started out rights of nature and lack of consultation. They won on lack of consultation, but lost on the rights of nature. But the Supreme Court picked up the case and said, this could be interesting for the rights of nature. So right now that's residing in the Constitutional Court. The same arguments are being used by the government that if the courts ruled in favor of the rights of nature, they would be violating the rights of corporations to work in Ecuador. So you can see the amount of pressure on these judges and these courts to give precedent to corporate rights. Of course, we're arguing is why should that be? Shouldn't beings have more rights than corporations? Are corporations alive? Are they a live entity? So it's very interesting, this corporate right versus nature rights. And Ecuador is setting precedent in this case. We are going to be needing a lot of help because, like I said before, we were just facing the Attorney General and Minister of the Environment. Now we're facing all these other state actors and private actor, the world's largest copper producer, that will be really pressuring the courts to say, look, we are in an economic crisis. I mean, the huge economic crisis. How could you possibly prevent corporations from working in Ecuador? Now, something interesting that we're not saying that in order to preempt a little bit of their strategy, saying, well, you know, you can't possibly survive without killing animals, which is true. That's why we focus on endemic species, which is something to take into account, but also critically endangered species. I mean, Ecuador, I suspect that most of the countries where everyone is from have signed the biodiversity treaties with the UN biodiversity treaties that really strengthen the conservation of biodiversity. And definitely biodiversity crisis is becoming a real big issue, as much as, I would say, as much as the climate crisis. So it's to our benefit to start looking into the biodiversity angle more and more. And maybe Ecuador is unique. I know there's so many, there's over 2,000 species, endangered species in Ecuador, including in the Ecuadorian red list, not only the IUCN, which is also, we're also arguing, we're also not only using the IUCN red list, but the Ecuadorian red list, which opens up a whole chapter and a whole resource to use. So I think biodiversity needs to be used more in the courts. Climate, the climate issue will also be arguing that the mining will impact our climate here. There will be so much deforestation that we believe the climate will be impacted, our climate in the INTAG area. So these are just some of the strategies that we've used. Now, the thing is that when I mention this case, I also like to put it into context. We've been fighting 26 years against mining development. The Japanese discovered copper in the 90s, and the government has been trying to develop it over and over again. The Japanese had to leave in the mid-90s, thanks to so much resistance on the ground. And then the Canadians came, and they had to leave in 2009, I believe, again, because of so much resistance. And in parentheses, for those of you who are interested in resistance measures, we took the Toronto Stock Exchange, we sued the Toronto Stock Exchange and the Canadian Mining Company in Canada. We sued the Toronto Stock Exchange for human rights violation. So the rights of nature is not the only tool you have. You may not have any critically endangered species or endemic species where you are, but you have to think more, you have to be more creative. We lost in Canada, which we knew we would because the mining lobby in Canada is unbelievably strong and powerful. But we actually ended up winning because the Toronto Stock Exchange kicked out the mining company from the stock exchange, which meant they had no money to operate. So it's a sort of a roundabout success. So there's all these measures to take into account and all these tools. You may not consider going to the courts worthwhile. We had to really think about it here because until recently, the courts were not independent. We didn't stand a chance of winning for the rights of nature until about 2 years ago. We saw this movement that the courts were becoming more and more independent. There was a change of government and a change of mindset. The judges were not so intimidated by the executive branch as they were during the Correa government. So we saw more independence, and there were other cases won. The COFAN won against mining. They mostly won because lack of consultation, but also the rights of nature was in that lawsuit also. The Waorani against petroleum, they won. The courts also ruled in their favor. Lack of consultation again. There have been rulings that have been very heartening. And so that's why we decided using these two frogs, which were found in 2016 and 2019, by the way. And the story how we found them is kind of interesting. We were able to get a little bit of funding from Rainforest Concern in England. And I had a hunch that if we found new species in the mining area, it would be a strong argument to win our case. So I hired this outfit that concentrates in amphibians to do an inventory in Junín. And the first night they were there, they rediscovered the species that had not been seen since 1989, as I believe, the one on the left, the long-nosed harlequin. Since 1989, rediscovery. It's only been found in this area. 3 years later, they found the one on the right, the confusing rocket frog, and this is much rarer. the biologist said that it would be like walking into a lost valley and discovering a dinosaur. It's an ancient lineage of frog. They had no idea it was still alive. And there's only one species in this genus. So if the frog on the right disappears, the genus will disappear. So it's a huge loss for the earth. And we were able to convince the judge. The judge, I mean, I have to say it again, she was really, really brave to go against these state actors who I'm sure called her up and pressure her. But again, it's part of this trend in Ecuador where the courts are ruling more and more in favor of people and nature. And I'm not sure when we'll go to the appeal. This will be at the state superior court in our province is Imbabura. Our lawyers think perhaps in January. Now, there's some interesting aspects of this ruling. One of them was that before, when a judge would rule in favor of, let's say, remediation, they would say, well, the Minister of the Environment has to prove that they've taken the measures to remediate or to prevent the impacts that will drive species to extinction. They would leave it up to the Ministry of the Environment. We never had any confidence that the Ministry of the Environment was going to do the right thing. So we asked the judge that final decision is whether the measures are enough to protect the species are taken out of the Ministry of the Environment's hand and given it to the local government, the local county government, and to a university. This is the first time it's happened in Ecuador. And that the whole process would be overseen by the public ombudsman's office. And I don't know what it's called in your countries. Here's the Defensoría del Pueblo, and they support people's cases. In fact, they are also they supported our case in this lawsuit. And it's also a precedent because the Minister of the Environment has always been complicit with the companies and mining operations, always. And this was proven because we also, in tandem with NGOs from all over Ecuador and from INTAG, we pressure the Contraloría is the Comptroller's office in Quito to do an investigation of mining projects, and ours was chosen. And this entity, the state entity, discovered all these illegalities committed by state actors in this mining project, in this copper mining project here in Intang. So the judge saw these, and this is why she also agreed with us that who decides whether there is enough measures being taken to protect the species is not only the Minister of the Environment, but these other local government actor, a university, and the ombudsman's office. So I'm very optimistic because of that ruling, that aspect of the ruling. It's just not, you go take care of this problem, Ministry of the Environment, and come back to us. No, it now has to be overseen by these other actors. So that's why I'm optimistic. And the government, I mean, not the government, but yeah, the Ministry of the Environment supposedly has until the 24th of December to prove to the judge and the local actors, the local government, the university, and the ombudsman's office, that they have taken enough measures, which is impossible because we know all the illegalities and all the flaws when the environmental impact study, huge amount of flaws. So it will be impossible for them to prove that. Now, there's also the case that the government is saying that the judge has no say whatsoever whether mining should go ahead or not. It's completely out of their hand. So they're trying to get the case thrown out. And they're saying that no one has the right to decide whether these measures are right or wrong, except the government, in this case, the Ministry of the Environment. So this will be very interesting at the appeal. If we win, it will be a huge precedent in that there's an amazing amount of lack of confidence with state actors protecting the environment. And I'm sure this is true in many countries. So if we could create this oversight mechanism that is not only dependent on state actors, but also civil society, like universities, local governments that hopefully are on the side of the people, there's a lot more chance that rights of nature cases will win. So this would be, keep tuned because this is very, very important from here on in. I think this is all I have to say. I would like to show you another photo. This is where the frogs were found. There's a waterfall on your left. The primeval frog was found on that waterfall that has this crystal clear water. The waterfall on the right is contaminated, as you can see. And there is no frogs on that part of these waterfalls. And this is only during exploration, which is something to keep in mind, that mining not only is harmful during the exploitation case, but during advanced exploration when they actually drill in deep to take samples of the earth. And to wrap it up, right now, there's been no mining since November 2018. And now there cannot be any mining until this case is completely resolved. Codelco, the world's largest copper producer, is trying to find a new a new partner, because the Ecuadorian state mining company they don't have any money to invest. And so now they're bickering as to how much the project is worth and trying to find another partner. This area is full of primary forest. Some of the last remaining cloud forests of Western Ecuador. There are many more endangered species here than the Amazon per the same area. Per hectare, there are many, many, many more endangered species in the mountain forest of Western Ecuador, which is cloud forest. It's very little known. Everyone is involved with saving the Amazon, and yet there's much more to lose in these areas of Northwest Ecuador especially. So I hope you can all give us a hand in getting the word out. We started a campaign called INTAG Santuario de Vida, or INTAG Life Sanctuary, to try and raise public awareness of this unbelievably important biological jewels that are endangered by not just mining, it's just mindless development. And if we're successful at the Supreme Court, this will end up in the Supreme Court, any mining project in Ecuador will be able, if they find critically endangered species, which is not difficult at all in Ecuador, they will be able to use this case as a precedent to protect their forest, their watershed, their communities. So wish us luck. Thank you.
Thank you very much, Carlos. And I'm sure we will all stand behind you. If you just send us a link here, I've already posted a few times a link to your blog where people can read more about this really, really historic initiative. And I really wholeheartedly hope you guys win, because wow, that will send, you know, waves throughout the world. And I'm sure a lot of people, including myself, will jump on that and try and use it in our own respective fights and struggles. So thank you so much for this presentation. I actually have tears in my eyes. So yes, we're all behind you, and definitely we will be sharing it as much as possible. I'm part of a Global Alliance for the Rights of Nature, and I'm one of the facilitators for the European Hub, the communication facilitators actually. So I'll be sharing, you know, the heck out of it. And get support. And it is actually in our inner rights of nature circles, as it were, it is really well-known case. And we are all rooting for you, but the point is to take it out, you know, not just in this our inner circle, but in our next circle and the circle after that. So for sure, we will do our best. So thank you so much for this presentation. I'm really so touched. Okay, now, as I predicted, we do have quite a few questions being posted here. So the first question is, I think, for Sue from Diane Skidmore. She says, not sure if it's too much to say, but everything is alive, even mountains and especially the virus. We and it are all one piece of energy. No? How would you... How would that fit within the law, within the legal system? Could we argue that?
Well, I suppose it's an argument for saying that rather than protecting one particular species, we should argue to protect the whole ecosystem. But you know, and obviously it's harder, it's easier to be protecting pandas than it is to be protecting slugs or, you know, some form of life that you can't see. But there still have to be decisions made about balancing between humans and nature and different parts of nature. You know, are you the fish in the river, you know, they're going to eat some other life, and then people are going to come and fish the fish or not fish the fish. People may need water from the river. So it's very complicated, isn't it? And the idea is that you go to court, and the court's used to making balancing decisions, but then who's going to go to court, and is it a fair court? So yeah, it's difficult. It's not black and white.
No,
but then there's scientific debates about, you know, what's living and what isn't living. And, you know, with the mosquito, if you don't want to be bitten by the mosquito, are you allowed to swat it, or you know, instead of using a pesticide, or can you trap it in a net and then release it somewhere? I think, you know, these are interesting and difficult questions.
They are. I completely agree with you. Somebody said here, and I agree with them as well, it's not just the law. You know, it's fine. We obviously do need our laws to change, but it also comes from our way of thinking and feeling. So if we were thinking in terms of rights of other living beings to life, our own behavior would change accordingly, laws or no laws. I mean, there are quite a lot of us who respect other living beings, you know, right to life, even though we may not have such laws to enforce that kind of, you know, thinking and doing. So concurrently with the law, we need to change our consciousness and the way we live and work. I think that's hugely important. I think somebody actually also mentioned that, and I really wholeheartedly agree with that. Being environmentalist, that, you know, that's where I'm at, and that's what I'm trying to push out there as much as possible. Okay, next question. Interesting. Maybe for well, for both of you, really. Do or should miners really have the right to injure, kill the natural environment? Is this the equivalent of giving a person the right to injure, kill another person? Which is an interesting question for us from London Mining Network. Anybody want to tackle that one?
Yeah. Yeah, well, like I said, I think we have to look at it as in a long term. People are not going to believe that just stepping on nature or digging a hole to plant a garden is killing nature. So there's a aspect of scale.
Yeah.
If you remove the topsoil and the subsoil to get at a mining deposit, you actually impact the whole ecosystem, because you can never recover that, especially open pit mines. You cannot. It's impossible to remediate. You cannot fill up a whole open pit mine. It's just too expensive. Mining companies don't do it. They just let it fill up with water. So it's a measure of scale. If you cut down a tree, you're not affecting the ecosystem. If you cut down 10,000 hectares in an area that's ecosystem that's maybe 50,000 hectares, you're definitely impacting nature. So it's a matter of scale. Artisanal miners that just live off what's on the river and don't use chemicals and pant for the gold, that's not really affecting nature. But once if that small scale miner or artisanal miner uses mercury, then that would be a crime against nature. See, so it's a matter of scale and impact. I don't know if that answers the question.
Well, it's actually, sorry, go ahead.
I suppose we have to acknowledge our own, responsibility, don't we? And are we all willing to change our lifestyle? So, look around wherever you are and see how much metal you can see, and think about your phone and the batteries and, your computer, and all of it has come from a mine. Probably most of it has caused some damage to the environment. And the case that I was talking about, the Paramos, was about saying that nature should be taken into account, but we have to take into account that we're often looking at countries that have been colonized by us, by the West, where we've had the benefit of the resources there, and people are living in very extreme poverty. So it's certainly about balancing nature so that it's there for the future, but we can't totally ignore the needs of those communities, and indigenous communities have a way of living against nature. But if some of that nature has been removed, then they may be forced to take a tree which they wouldn't take previously. So I think it's difficult. I feel it's difficult for me to be passing judgment on somebody who's in a very impoverished situation. But I'm interested to know what other people think about it. It's an interesting debate.
It is a very interesting debate, and actually I'm thinking of our next webinar maybe just be just a webinar, just a discussion, just 1 hour, half hour of discussion rather than having presentations, because there are so many questions that people have and answers. Two things I just wanted to add on to what Carlos said. It is a matter of scale and impact by all means. And as we speak, there are top end lawyers drafting the actual definition of ecocide, what ecocide is, because the law of ecocide was reproposed by Polly Higgins in 2010, because it was originally proposed in 1973 by Olof Palme and then Richard Falk, who's actually going to be a judge in my case on the ecocide of small dams over the Balkan rivers, and I'll post the link to that bit later on. And 10 years later, on the 75th anniversary of the introduction of the word genocide after the war, we now have a group of top and lawyers drafting the exact definition of ecocide, and that's dependent on the scale of impact, physical scale, and the time scale. So as you say, it is a matter of proportion. And to add on to what Sue was saying, Sue completely agree. I mean, I come from Eastern Europe, and we are at the moment being colonized by Western corporations big time, especially the mining corporations. They're using us both as a place to trash, to put all their rubbish, to take away our resources, to exploit our people. So I can't say I feel like somebody from Africa, but it is getting there, and it's not a nice feeling. But rights of nature, and I'll post a link to a very good article about that, will change not just in law, but the law itself will then change how we live and work, and it should become far more balanced. It should reduce our own consumption and help other communities which need to raise their standards of living to a higher level but maybe without destroying nature as, you know, as the Western world has done so far. So whichever way I look at it, we need rights of nature to help us out of this horrible mess. Okay. Okay, another question. There are no-go areas in India. Oh yes, somebody talked about, yes, that was Karina Gustafsson from Sweden. She's another colleague of mine working on rights of aquatic ecosystems in Europe. And she was mentioning, she was actually asking, should there be no-go areas around mines? What do you think about that?
Yeah, yeah. There should be red lines to not only mining, but any activity. In the case of mining, I was actually working with an organization in Germany to make it clear for mining companies where they shouldn't go. Number one, there has to be genuine, free, prior, informed consent, or at least consultation, but it has to be genuine and not manipulated. That's a red line. Wherever there's endangered species of extinction, I would say that's a red line. Wherever there's a chance of a mining development generating acid mine drainage, which is incredibly damaging to the whole environment, the whole aquatic ecosystem, that should be a no-go circumstance. There are a number of these. In fact, I wrote about it in this, if I can remember, I'll try and remember on a post-it. There's about 8 or 9 circumstances and areas where there should be no extractivism whatsoever. But you start with the will of the people who live on the ground. I mean, who has the right to mine or destroy an area? Someone in Quito that can sign a concession, or the people who actually live on the land? So if you don't have their consent, it makes no sense whatsoever to allow any kind of extractivism. So you start with that. That's a no-go situation. There are several others.
Yeah, that's very important what you just said, because where I come from in Serbia, where, as I mentioned, we are fighting of Rio Tinto's huge lithium mine. And lithium is one of the most wanted metals at the moment, new gold, so-called new gold. Obviously it will cause a lot of damage, and it is Rio Tinto. We all know, you know, what they leave in their wake. But the most important thing is people just don't want it there, period, end of. It's an agricultural area. People live on their, you know, on their farms, on the land. There's a big river passing through. There are 4 natural protected areas. We just don't want it, period. You know, but they still keep pushing it because they keep, you know, arguing this very false argument that we need these lithium batteries so we do not burn fossil fuels. So, you know, we reduce the climate change, and that's a whole another kettle of fish. We can talk about that separately. So, but I just want to emphasize what you're saying. If the local community don't want it, period. That's it. That should be the end of that particular argument.
Yep.
So I agree with you.
I think the question about the lake is very interesting because it gives us a kind of practical example. Within Europe, there's plenty of legal arguments about not putting a mine next to a lake in relation to pollution, like, you know, the Article 8 rights under the Human Rights Convention to do with, you know, our right to family life, and arguments about the right to healthy environment that have been used in Spain. But we have a lot of campaigners here, and I think it's interesting to think about different ways of approaching it from a campaigning point of view. So in Spain, again, people are currently arguing that a lagoon should have legal rights. So the idea of the lake having a personality could be something that would capture the imagination of people in that area. And similarly, the idea of protected zone around the mine or around the lake could work well, it seems to me, as a kind of campaigning activity. And then people start getting involved in, you know, that aspect of nature, and they kind of take more notice of it, hopefully, like hopefully they did with the frogs. And you know, then that's part of the process, isn't it? It's not just about a kind of cold legal case. It's also about the community learning about what's around them, the kids, you know, learning more about nature around them, and just getting involved in, you know, cleaning up the lake or whatever else needs to be done at the same time.
Yeah, it's a very good point, Sue. Thank you. And as I mentioned, there is a very interesting case going on right now in Sweden. And I will post a link to our tribunal where one of the cases there is this Swedish lake, second largest lake in Sweden, which is fighting off all sorts of problems there, one of them being mines. An interesting question, I think, might be for Sue. It says in Peru, the movement around the country are pushing an agenda focus on a constitutional process that opens the possibility to discuss the rights of nature. The question is, what are the lessons from the same process in Ecuador? Sorry, that would be for Carlos then.
Could you repeat that again?
Yes, of course. Well, in Peru, there are there are initiatives to push on the agenda a constitutional process to include possibly rights of nature. So the person is asking, what are the lessons from the same process that happened in Ecuador that they can, transpose to Peru?
Yeah, if they're writing a new constitution, I think that was our opening in Ecuador. They were writing a new constitution. Civil society, I myself, along with many people from MINTAC, actually went to where the drafters of the constitution were working. We met with the authors of the new constitution, along with indigenous people from the Amazon and other parts of Ecuador. There was a lot of civil society on the writing of that new constitution. In fact, if anyone's from Chile, Chile is writing a new constitution, and they're thinking of adding the rights of nature. So there has to be a lot of civil society pressure on the people who are writing the constitution. Keeping in mind, in the case of Ecuador, there were mining lobbyists every day were talking to the drafters of the constitution. So there also has to be civil society people like us meeting with those people who are writing the constitution to convince them of the right. There's several organizations specializing in the rights of nature. The Global Alliance for the Rights of Nature has a lot of information about Ecuador's whole process. Or you can write me and I can put you in touch with them to see how that came about. But there was a lot of civil society pressure.
So yeah, that's always the key. A lot of civil society pressure, by all means. There is just briefly, if somebody can answer this, because there's a lot of us from Europe who might be interested in this. Said, what about EU protective laws in the Habitats Directive? Could they be extended or made stringent even more so? We had that question at another panel recently, and we were discussing should rights of nature be included within the directives, or should we have a separate law and the directive which will be above them? And I think the consensus was that we should have an actual rights of nature law or directive which will be above the existing directives. But what do you think, Sue?
Well, those are often the Birds Directive and Habitats Directive are often given as examples of a rights of nature law. They're the closest that we've got to it, because they're saying that you can't, well, you're not likely to be able to build, say, a mine if it's going to result in damage to the greater crested newt or a bat or other particular types of wildlife. But you've still got the difficulty of implementation and, the developers with lots and lots of money. So you don't, the access to justice is the barrier. And I think that's probably why you concluded that you still need a rights of nature law. And also, I've been involved in cases. You were lucky to find your frogs, Carlos. I guess there was no shortage of wildlife, but you can imagine that in the UK, where lots of wildlife has gone, people may want to build an incinerator, and we can't find the particular type of bat or the particular type of bird or whatever it is, greater crested newt, to argue that they shouldn't build it there. But there may still be wildlife. It's just not the right kind of wildlife.
Well, that really shouldn't matter. Then there are always people. I mean, our health and well-being is part of nature rights because we are part of nature. So, I always try and argue that point as well, because we are nature. We have rights to healthy life, don't we? And I've just come from Belgrade a few weeks ago, which happens to be the most polluted city in the world, amazingly, in the middle of Europe. And I've been ill since. Yes. Yes, if you look up the list of cities with the most polluted air on planet, it's Belgrade. It is horrendous. And I've been ill since, 4 weeks later, I still, and I live in London, which is also highly polluted. So, if I from London cannot stand the Belgrade air, it should tell you something. So yeah, we have rights to as well. So, that can be argued. Very interesting question, and one that raises a lot of polemics, outside of our circle, and there are a lot of governments pushing this, and I personally can't stand it. There's been a lot of interest and activity in placing a monetary value on nature to incentivize businesses to conserve it. So, how might ideas of natural capital support or work against the rights of nature?
That's a good question. Sometimes, and we struggle with that question because one of the issues is that the government doesn't see any value in forests by itself. And the companies say, well, it's not being used, it's not generating, it's not helping the economy. So we can help the economy by exploiting this forested area and so forth. So we actually hired, I think 2016, I forget what year, we hired this outfit in the US called Earth Economics to put a price on ecosystem services. And now we can show the government that this area produces $447 million per year in ecosystem services in perpetuity, which miners can never compete against that. So, and I was not too crazy about doing this because, it's hard to put a price on species. It's impossible. But that's all these idiots in the capitals that sign mining concessions, that's all they care about. How much money can this plot of land produce? So now at least we have that argument. If they say, well, show us that this land is productive, we can show it that it's productive. It's agricultural land, it's primary forest, there's rivers and streams everywhere that you can make hydroelectric, etc. Botanical plants, medicinal plants, all that. The government now, we have this to show the government in case they ask for that information.
It's difficult, isn't it? I'm glad that you've managed to win that argument locally, Carlos. It's like a short, I suppose in a way I see it as a short-term argument. It's like, let's carry on flying and we'll just plant some trees as carbon offsetting, and we really want people to not be flying in the way that they do at the moment, because the reason the mining, it's the capitalist system of an approach to property, which is our problem, isn't it? And that's what we're trying to change. Exactly. Fundamentally, the way people approach things. But I can see that if we can win a short-term argument in a particular part of the world, or to save a particular ecosystem or species, then it may make sense.
Yeah, no, it's damn if you do and damn if you don't, right? Because these guys, it all comes down to this difference of cosmovision or paradigm. And it takes a while to change the paradigm that we want, that not that we want, that our humanity needs. We need to see nature, that we are really part of nature. So if we destroy nature, we're actually destroying ourselves. That takes time. That takes time. And in the process, these cases that are being fought in court are steps towards that paradigm. This is one of the, I think, the most important things about cases like ours and Los Cedros and the Cofan case and the Guaranis, little by little, we're showing the world exactly that the nature does have rights. People on the ground have more rights than corporations. It takes a while. So if on the way to that, you can show the world, wow, these forests really are productive. The rivers, I mean, the clean water and stable climate, how much is a stable climate worth? What does it take to have a stable climate? Well, you need forests, you need biodiversity. So little by little, but it's a hell of a struggle. Let's face it. Let's be realistic. The paradigm that destroying this earth and people and everything is very strong, and it's very well deeply rooted. It takes time, but this is what we do with these cases. Little by little, we just a little bit of grain of sand is helping to change that paradigm.
I completely agree with you. And hopefully that will happen quicker rather than, later, because we don't really have that much time. But I think this avalanche, is gaining momentum. I think we will get there at some point. Very interesting question that that relates to that a bit is, from all the global examples so far, what would you say is the most effective way to try for rights of nature at the constitutional, state level, municipal, local level, or maybe ecosystem, or as we've been seeing so far, like rivers and mountains? Where do you see the biggest impact and the most success?
Is that a question for both of us?
Yes, for both of you, whoever would like to answer.
Sue, do you want to go first?
I think we're still in the early stages of rights of nature, and beggars can't be choosers. So anywhere we can get a way in, I think we should try to get our way in a bit, as Carlos was saying just now about the green, finance approach. But if I had a choice, I think that having strong statutes and laws rather than a case here and there is desirable. At the same time, though, there has to be the raising awareness and the local involvement and activity and campaigning, because the advantage of a local case, as I was talking about with the lake, is or the rivers, is that people really get involved, and then their name will, because the river's not going to be protected by somebody, in the capital somewhere. It's going to be protected by local people noticing that the fish are dying, and that something's happening, and taking some quick action about it. So whatever laws we have, I mean, Colombia has wonderful laws, but unless there's means of enforcing them, and local communities are involved, and we change our ways of living, then the laws will be empty. Carlos.
I agree. I think lasting change has to come from the bottom. And so in 1997, we started writing a local law, an ordinance at the county level called the ecological ordinance. It took 3 years because we had nothing to copy. It was unique. And this came from right here, from the Intag area, the people. We helped push it. We helped the local government adopt that law. We had to write it. I'm one of the authors of the local ordinance. And it was the first county in Latin America, perhaps the world, to become an ecological county. So that created the right mindset for people to adopt other environmental measures to protect our forest. And this is one of the best protected areas in all of Ecuador. There's 41 community and local government protected areas that we helped create, as a matter of fact. So if you don't start at the local level, you stand a chance of it not being long lasting. If the local people pressure for change, you're more likely to get long lasting and more secure changes. That's why it's not enough to have a constitutional amendment. I'd say you have to start at the local government and the provincial government and build up so it's long lasting. In Ecuador, that process was jumped, but it's taken 12 years, 10 years for it to be slowly adopted by the courts. Have we started from the bottom up, I think it would have been quicker. But I agree with Sue. I think you take any chance, any opening possible, because, I mean, our biosphere is in dire strait, and this is one tool not only to prevent mining, but to slow down this ecocide at the global level.
Oh, I agree. I mean, we've come to the end of our session, and those are very good words to end on. It is a community-driven process. It has to be community-driven process. It has to come from the bottom up, as you say, if we are to have any lasting impact on this, because putting pressure from above will just create pressure back, and people will not really understand why we need to protect all life. So changing this thinking, the paradigm shift is hugely important. I very much agree. So we are working on that. I've posted towards the bottom of the chat a few links for everyone to read up on rights of nature if they're so interested. And there are 2 membership forms. If you are in Europe, there's a Global Alliance for the Rights of Nature membership form if you guys would like to join us, because we are doing really interesting things. And rights of nature are spreading in Europe, especially in France, a little bit in Netherlands, Sweden, Spain, Germany, yeah, quite a few countries at a huge speed. But if you are outside of Europe, I've also posted the Global Alliance for the Rights of Nature global membership form. There's also a link to our European Tribunal for the Rights of Aquatic Ecosystems. And one of the cases will be the Swedish lake case, where they're working on trying to gain rights of nature for the second largest lake in Sweden. And one of the enemies, if I can call them that, are the mining corporations there. Wiki on rights of nature has really good resources there. And while we were talking about rights of nature versus development, there's a very good text, Nature's Rights, a New Paradigm for Environmental Protection, where Mumtaito, one of the activists on rights of nature, discusses that very issue and how rights of nature can actually change the way we live and the way we work, and how we can actually develop and raise our living standards without killing the world around us. And somebody also mentioned degrowth, by all means. It's a finite planet. We cannot keep growing, whatever that means, indefinitely. We cannot keep taking, we cannot keep killing, we cannot keep extracting things from this poor little planet. And people say planet and nature doesn't have voice. Oh, they have voice, and they're telling us, they're actually screaming in agony, and some of us are screaming with them. So, but certain individuals refuse to hear that voice, and that's why we here are trying to put that voice into law, and then they will have to hear it. So I see there are a few more questions here, but we have really run out of time. And I know Sue is very tired from 2 days of strenuous activities on rights of nature. So I won't keep you any longer. This session's been recorded, so it will be posted on London Mining Network's website. And in the meantime, if you have any questions or you can email it to us. We'll try and answer them in the next session, which hopefully will be sometimes in January. We haven't really decided yet. We're doing this slightly ad hoc. But I think an open discussion on all these questions should take place. So on that note, I want to thank our speakers, Carlos and Sue. Thank you so much for everything you've said here, and Carlos especially. You really touched me deeply, and two little frogs.
Thank you for doing all this. Thank you.
No, not at all. It's my last mission. We need to do it. We need to do it, for all life out there. We have no right to inflict pain on anybody. And, you are setting such an important precedent that we are all behind you. So thank you so much. And hopefully see most of you at our next session sometime in January. Stay safe, stay well, try to relax, and happy forthcoming holidays.
Bye
Bye-bye.
from me, Doug.
Take care, everybody. Bye-bye.